Good morning and welcome to the recording for Class 2 Domestic Relations. This is for Wednesday, August 18th, and what we are talking about today, Wednesday, August 18th, is the A of campers. Remember, constitutional law has 25 questions on the MBE. 12 of those 13 questions are questions over individual rights. Individual rights as tested under constitutional law on the MBE are camper, contraception, abortion, marriage, procreation, education, and relationship. Camper. Day one, which was August 16th, we talked about the individual right to use contraception for married people and for single people, okay? So again, individual rights are this umbrella. Under this umbrella, CAMPER. Monday the 16th, we covered contraception. Today, we're going to cover abortion. Getting started with abortion. Before I go there, let me ask, any questions? Nope. Hopefully you are working on your weekly outlines, because your weekly outlines will be the outlines that you need for your final exam. Your weekly outlines are also going to be the outlines that you're going to use for your formative assessments. Here we go. Abortion. Roe v. Wade, 1973, defined as a landmark case. In class, I took a moment and asked, what is a landmark case? Why is a landmark case any different from any other case? Question. Waiting for some students to respond. Moving on, make a note to yourself in your outline that you should know what a landmark case is. Not just because it's something that I might test you on, but because you're going to be lawyers. And that's our language. And in our language, those words have a significant meaning. And you should be able to use the language of our profession effectively, proficiently, and persuasively. That's why it's important. Roe v. Wade is a landmark case. It is not a landmark case because it gave women the right to seek legal abortions. It is not a landmark case because it gave women the right to seek legal abortions. Okay. It is a landmark case because it identified under the right to privacy in the 14th Amendment and introducing the concept of the right to exercise your liberty interest implied in the 14th Amendment. For women to be able to seek to have a legal abortion when their life is not in danger as a result of the pregnancy. Okay. Before Roe v. Wade, there were legal abortions. Before Roe v. Wade, women were able to seek legal abortions. However, they were only supposed to do so if the pregnancy endangered their life. And in Roe v. Wade, that's not the situation, right? In Roe v. Wade, this was her third child. They already had difficulty with the other two children. And Miss McCorvey, who was actually Jane Roe, sought to have an abortion because she knew the law, And because she knew that she didn't meet the legal qualification because her life was not being endangered by the pregnancy, Miss McCorvey lied and said she was raped, hoping, I guess, to find someone empathetic, sympathetic, some compassionate soul to try to convince. It didn't work. So lawsuit is filed in 1971 to challenge the Texas statute that prohibited abortion except for when the woman's life is in danger. And that challenge was the law was a violation of Ms. McCorvey's right to privacy. Good one, right? So here we go. Under the 14th Amendment, we know through Griswold, we know through Eisenstadt that the Supreme Court has identified an implied right to privacy. That right to privacy is said to be fundamental, necessary, essential, vital. And because it's fundamental, it rises to a level of protection under the law that requires a state who wants to interfere with that fundamental right to do a couple of things. One of those things is the state is going to have to establish that state interference is because of a compelling interest. And the state interference is narrowly tailored to meet the objectives of that compelling interest, right? And so now we have the fight. Roe McCorvey saying, I have an individual right to privacy. That individual right to privacy is held within the 14th Amendment. And unless you, Texas, state entity, government entity, can establish a compelling interest and a method of exacting that compelling interest that is narrowly tailored, get out of my way. So, the case is decided in 1973. Mind you, the case was filed in 1971. The case was decided in 1973. Normal gestation for humans is not 2 years. So clearly, that's a conclusion. McCorvey must have given birth, or even if she didn't give birth, the duration of that pregnancy was over by the time the case was decided. What is the mootness doctrine? And how was McCorvey, AKA Jane Roe, how did she have standing to pursue the relief that she sought? Because at the time that the case was taken up, she was no longer pregnant. Might need to know that. What is the holding in Roe v. Wade? The holding in Roe v. Wade is yes. But wait, what was the question? Does a woman under 14th Amendment right to privacy have an individual right to seek a legal abortion when her life is not in danger? Answer, yes. The court found not only under the right to privacy, but now enter the right to liberty. A woman has a right to elect to seek an abortion, even when her life is not in danger. Answer is yes. Got it? Nice. The court introduced the concept of trimesters. Why? Well, Because in its rationale, the court decided, while we are not going to answer the question that everybody is waiting with bated breath for me to answer, us to answer, which is, when does life begin? That was the question. The court navigated around that and said, not going to answer that question, but we will acknowledge that there is a continuum by which this unborn life grows into a form that deserves legal protection, right? We don't know exactly when life begins. We're not going to talk about it. And so for the first trimester, if the woman chooses to elect to have an abortion, not a whole bunch that the state can say. And for the most part, the state's hands are going to be tied and must yield to the privacy right and the liberty interest of the individual woman to exercise her rights to privacy and liberty, to choose to elect to abort her pregnancy. What happens in the second trimester? Because in the second trimester, clearly the fetus is growing, right? And in the second trimester, the court said, there can be some regulation proffered by the state as to a woman's right to exercise, to elect an abortion, but the guide is going to be mom's health, right? State could not intervene unless a mother's health is at risk, right? Second trimester, want to have an abortion. The state is now saying, well, we're going to work to protect the mother's risk, so we're going to let the mother's health be our guide. What happens in the third trimester? The child, the unborn child's interest becomes full term, excuse the pun. In the third trimester, once, right, it is assumed that the fetus is viable, meaning that the child could survive outside of the mother's womb. And in the third trimester, the state may restrict the right to an abortion, but must always include an exception to any regulation, right? So while the mother has a right to privacy and a right to liberty, it's not absolute. And in the third trimester, while the state has the right to be a more active party to interfere with the election of an abortion, because it's deemed at that point that the fetus is now viable, the state now has the right to jump in and say, but there must be some consideration given to exceptions, right? Not carte blanche. Questions? Roe v. Wade, privacy, liberty, 14th Amendment, right to choose, termination of your pregnancy, AKA abortion, first trimester, yeah, not too much interference to be expected. Second trimester, we're going to be guided by the woman's health. Third trimester, it's all about the baby. And that's where we are. Question: does Roe v. Wade require the interest of the mother's health and her right to privacy to be balanced against the fetus's viability? Think about it. Question: what did Roe v. Wade add to the legal discourse of the concept of privacy as an individual right? Question: what level of scrutiny did the court choose when they reviewed Roe v. Wade? Question: who are the abortion laws created to protect? Questions? No questions? Let's move on to Planned Parenthood of Southern Pennsylvania versus Casey, 1992. Fun fact: Planned Parenthood v. Casey comes 19 years after Roe. Fun fact: in 1973, when Roe was decided, there was more of an equal distribution of justices that were appointed to the Supreme Court from Democratic and Republican presidents. Fun fact: by the time we get to 1992, 8 of the 9 justices that are sitting on the court hearing Planned Parenthood v. Casey were appointed by Republican presidents. Question based upon a fun fact: what was the intent of Planned Parenthood v. Casey? To overturn Roe. Finally, right? Here's the chance. Here's the opportunity. While the focus of Roe v. Wade was that of privacy, and in determining their holding as to the issue of privacy, the court added the concept of liberty. What was the focus in Planned Parenthood v. Casey? Was it a privacy issue? Think about it. It wasn't a privacy issue, right? Because the privacy issue had already been settled. What was going on in Planned Parenthood v. Casey? Check it out. The Pennsylvania Abortion Control Act of 1982, that's 10 years prior to the lawsuit. The Pennsylvania Abortion Control Act of 1982 contained 5 provisions as it related to abortion. The Pennsylvania legislature said, not gonna start messing around with a woman's right to privacy to choose. We know that that's been established. We're not gonna go down that road. But this is what our brilliant minds, and I don't mean that facetiously, because as a lawyer, you have to think strategically. If one way is blocked, you've got 2 options. 1, stop, because the way is blocked. Or 2, figure out a way around the block, right? So the legislature said, let's figure out a way around the block. Sure, you can have access to a legal abortion, right? We know the trimester system, your first trimester. We know that we as a government have very little regard to that area and will not be considered graciously if we try to interfere. So we're not going to mess with your right to elect to have it. But what we're going to do is we're going to put some conditions precedent in place. We're going to put some obstacles in place, right? I use the word obstacle. The legislature did not look at these at all like an obstacle, right? They said these are common sense things. Number 1, woman wants to have an abortion, first trimester, legal. Doctors, we're going to put it on you to provide informed consent. Tell these ladies everything. so that when they sign off on the paper to authorize you to abort their child, they know exactly what it is they're consenting to have done. Number two, 24-hour waiting period after you've informed them. So not only do you have to give them all of the details, they have to sit with it for 24 hours before they can execute the consent and actually have the procedure done. Number three, if it is a child who is pregnant under the age of 18, the child would have to provide parental consent for the surgical procedure. Number four, women had to sign a statement saying that they had told their husbands about their intent to have an abortion. Now, my legal mind says, oh, okay, so was it just women who were married? So if I wasn't married, I wouldn't have to tell the father that I was having an abortion, or what if I didn't know who the father was? Don't know the depths of the law that detailed. Don't need to get into the depths of the law that detailed. We've got the fourth provision, which says that a woman had to sign a statement saying that they had told their husbands about their intent to have an abortion before the abortion was done. You can do this post-abortion, right? And number five, the doctors had to agree to report requirements of abortion stats to state governments. Wow. So I have a right to get an abortion. First trimester, don't anticipate that there's going to be any issues. Let me just call a doctor who I know that performs abortions and let me go make an appointment and let me go get it done. Oh, wait. No, I like informed consent because I like to know what you're going to be doing to my body. Oh, but I got to wait 24 hours? Okay. Oh, I got to sign a statement telling you that I've told my husband. Oh, as my doctor, you are now required to count me and your statistics and give those statistics to the state. How do you argue this case? What issue statement would you set this case up for? What's the legal question that needs to be answered? Holding 5-4. Due process clause of the 14th Amendment prevents states from unduly interfering with a woman's right to abort a non-viable fetus. I just said a mouthful, and for us legals, we understand that there's a lot to unpack in that holding. Here it is, 5-4. Roe v. Wade was 7-2 in favor of privacy, including the right to abortion with the trimester schedule. 19 years later, oh, we are so close, 5-4. Okay. 14th Amendment due process prevents states from unduly interfering with a woman's rights. That is going to be translated to undue burden. So what does it mean? It means that states can't come up with all of these obstacles, these burdens, these things that women have to overcome to actually be able to access the abortion service that by law I have a protected right to choose. Got it? Fun fact, Judge Alito, who is now on the United States Supreme Court for life, at the time that this case was appealed to the Third Circuit Court of Appeals, he sat as a justice on the Third Court of Appeals. As a justice on the Third Court of Appeals, Justice Alito thought that a woman telling her husband that she intended to abort their child, presumably their child, was constitutional, wasn't unduly burdensome, did not put the woman in a precarious situation as to safety or economic insecurity. And I'll say it again, actually thought that provision was constitutional. He's still on the Supreme Court. Okay, so number one, a woman has a right to abort a non-viable fetus without undue interference, right? That's that undue burden, undue interference. Number two, states can restrict abortions after viability. We know that from Roe, right? As long as there's exceptions for pregnancies that endanger a woman's life, right? Clearly, the state has a legitimate interest in protecting a woman's health and the life of a fetus. Did you hear what I just said? Listen, listen, listen. As a lawyer, our superpower are our words. Did you hear me? States have a legitimate interest in protecting women's health and the life of a fetus. Legitimate interest, that's not strict scrutiny. Strict scrutiny is compelling interest. What did Planned Parenthood v. Casey add to the discourse of abortion rights? No more strict scrutiny. No more trimester. Now, the determination about pregnancy is determined based upon the child's viability. And nowadays, right, I mean, we're doing things that were unheard of back in 1973 and 1995, right? So viability is a moving target that it's still difficult to nail down, but it definitely gives the state a greater opportunity to be able to interfere with the exercise of that privacy and liberty right. Because if there's an argument that the child is viable, not happening, provided that the pregnancy isn't putting the mother in danger, right? And no longer does the state have to prove a compelling interest that is created or that is protected from a narrowly tailored way, right? Now it's just a legitimate interest. So while it upheld Roe v. Wade, which is privacy and liberty include the right to choose to have an abortion, it definitely opened the opportunity gates for states to be a more active participant in interfering with a woman's right to choose. Got it? So no longer is the standard going to be strict scrutiny. No longer is the standard a compelling state interest. No longer is the guideline of the trimester. And with Planned Parenthood v. Casey, it's now a matter of viability versus trimesters And it's now a matter of making sure that the state doesn't create any obstacles, substantial obstacles in the way of a woman accessing the abortion, right? Because if there's substantial obstacles in the way, that is going to be considered an undue burden question. Okay. That's where class ended on Wednesday, August the 18th. On Monday, we're going to review Planned Parenthood v. Casey. We're going to jump into Whole Women's Health v. Hellerstedt. And then we're going to complete this with June Medical Services. And that will be the completion of our review of the individual right of abortion as protected by the 14th Amendment privacy clause, including also liberty. If you have any questions, let me know. If not, I look forward to seeing you on Monday.